Please be ready for dictation of an extract from the Gujarat High Court Judgement. It is taken from Virabhai Karshanbhai Vankar versus State of Gujarat, Citation 2023, Latest Caselaw, dated 10th November 2023. 5 seconds. Your Lordship may be pleased to issue appropriate writ, order, or direction and quash and set aside the action of the respondent authorities of not releasing the periodical yearly increment preceding for discharge of duties by the petitioner for a period preceding the 1 year preceding the first week of July of a respective calendar year in which the petitioners attained the age of superannuation, and therefore the said action of the respondent authorities for not releasing the last yearly periodical increment to the petitioner, though the petitioner have attained the age of superannuation on 30th June of the respective calendar year and became eligible for and entitled to get yearly increment. The aforesaid action for not releasing the yearly increment is arbitrary and illegal. Your Lordship be pleased to direct the respondent authorities to pass appropriate order for making payment for releasing the periodical yearly increments which has become due and payable to the petitioner as the basis of discharge of duties from the first week July in which the petitioner attained the age of superannuation, and the Honorable Court may issue further direction to the respondent authorities or may kindly be directed to recalculate last pay drawn by the petitioner after addition of yearly periodical increment in the salary and wages of the petitioners, and the Honorable Court may kindly direct the respondent authorities to recalculate, revise the pension, gratuity, leave encashment, and other consequential benefits after addition of the aforesaid increment in the last pay drawn by the petitioners, and the difference of salary may kindly be ordered to be paid with 12% interest from the respective date of superannuation of the petitioner. The factual matrix in the present case is that the petitioner retired from the service on 30/6/2019 on attaining the age of superannuation. It is the case of the petitioner that he has rendered 1 full year of service before retirement, and therefore he was entitled to get the benefit of annual increment for the said period of service. That, as per the policy of government, the said increment falls due on 1/7/2019. However, as the petitioner had retired from service on 30/6/2019, he was not granted the said benefit of annual increment for the said period. Aggrieved, the petitioner has preferred the present special civil application. Learned advocate appearing on behalf of the petitioner, submits that the issue with respect to grant of increment after retirement has now been settled in the decisions by the division bench of this court as well as by the Honorable Supreme Court. He submits that in the case of State of Gujarat versus Takhat Sin, Uday Sin, Songara, and another, being letters patent appeal number 868 of 2021, decided on 27/4/2022, the division bench of this court has held that the government servant is entitled to undefined increment becoming payable on 1st July and the retirement of the government servant on the day prior to the increment becoming payable is only fortuitous circumstance. He submits that the said judgment was challenged before the Honorable Supreme Court by way of preferring special leave petition civil diary number 26295 of 2022, and the Honorable Supreme Court was pleased to dismiss the special leave petition since the order of the division bench was complied with by the state government and the issue was kept upon as the issue was at large in other matters pending before the Honorable Supreme Court. He further submits that the Honorable Supreme Court has upheld the view of the division bench of this court. It has been held that denying a government servant the benefit of annual increment, which he has already earned while rendering specified period of service with good conduct and efficiently in the last preceding year, would be arbitrary and unreasonable. Stop.